My name is Eileen Mostricht, and today I wanted to talk about the question of what should you do with your estate planning documents once they're signed. So first, the healthcare documents. So you should have a designation of healthcare surrogate and a living will if you wanted to sign that one. Those should be given to your healthcare providers, at least your primary care physician. They will want to just scan them and they'll be so happy that you have them, but they should be given to them. Now, next time, if you ever go into hospital, they do pre-op and they always, shove those documents in front of your face to sign, but you don't have to re-sign them. You've already got those documents, they're signed. Bring them to your pre-op if you go. But in the meantime, next time you go to the doctor, definitely give them a copy. They'll usually just scan it and give it back. The durable power of attorney. This is a very powerful document. It is effective right away in Florida. And of course, as hopefully you were advised and we advise that the person that you're naming should be somebody that you trust. If you don't trust that person, you shouldn't even be naming them. But it's a good idea to give them at least a copy of the document. You hold the original. The copy works almost all the time fine. Once in a while, though, somebody will ask for the original, and so you will need to tell them where you keep the originals. The will or the trust. My recommendation with the will or the trust is not to give that out yet, because you could change that for the rest. You have the rest of your life to change that. And if somebody has especially if they're a beneficiary, they have a copy and you change it later, things can get a little bit sticky. Not that you're not allowed to change it. You can certainly change it as long as you have capacity for the rest of your life. But people start to expect things when they see themselves named as a beneficiary. And then if there's a later document that they're not in, it just gets a little sticky. So the best solution, in my opinion, for the will or the trust is just to tell a couple important people, namely the people you've named as your personal representatives in that will or the successor trustee in the trust, where you're going to keep that document. Now, the originals, where do you keep them? Some people like safe deposit boxes. I am not really a fan of them because they're very difficult to get into after you pass away, unless you have named somebody, or put somebody on that box as well who can get in even if you're not there. Some people don't really know completely whether they have or not, and you got to read the small writing. Sometimes you put somebody else on the box and they still require you to be there. The will and the trust. If the will is ever needed, the original is needed. So what I recommend is putting it in like one of those big giant Ziploc bags that they make now, and then putting all of the documents into that and putting it on a closet shelf. And just because now it's above ground in case there's a flood, and also it's in plastic in case there's a roof leak, and you just say, if something ever happens to me, this is where my documents are. So those are my general recommendations about these documents. If you have a fireproof safe, that's great too. If you have a safe in your house, that's fine as well. But again, make sure things are above ground, and that's if you are going to put it in some kind of secure thing, make sure that there's somebody else, at least one person, better two, that can get into that box or safe or whatever it is.